All right, now let's get on to the nitty-gritty of some of the legal and practical details of the foreclosure process. Really becoming good at mastering your trade. Number one, what is a mortgage? Well, a lot of people think of a mortgage as a note, and a note is a mortgage, and the debt is, it's all one thing. It's just called a mortgage. Not really. There's two parts to what we call a mortgage. You go to the bank, you borrow money, and you sign a note. We call that a debt instrument. Then you sign a collateral instrument called a security instrument. Now, you don't give a deed to the property to the lender like you do in the car business, right? In the car business, you actually give title to the lender to hold for you, and then you pay it off, you get the title. In the mortgage business, you give a collateral in the property in the form of a lien, which is a security instrument. And that security instrument is two types: mortgage and deed of trust. We'll get to those details in just a moment. So a security instrument is recorded against the property. You have the deed in the name of the owner, and the security instrument recorded in favor of the bank. Does that make sense? What about the note? Do we record the note? No. Who holds the note? The lender holds the note, the original note. Okay? All right? So we've got a mortgage is a debt instrument and a security instrument. Bless you. So who are the players? Owner, borrower, mortgagor. Lien holder, lender, mortgagee. That's on a mortgage instrument. Now, about half the states use mortgages. I don't think anyone here is from a mortgage state, right? You use mortgages in your state? You do use mortgages, okay. So in a mortgage state, it's a little simpler. To release it, you just sign a release of mortgage, and then you record it. Very simple. So you have a note and a mortgage. There's two parties to the equation. There's the lender and the borrower, or owner and lien holder, or mortgagor or mortgagee. In a deed of trust state, it's a three-party transaction. So we have the borrower, who's also the grantor, grants a deed in trust to the public trustee, and those of you in California, Texas, private trustee, for the benefit of a lender. It's sort of like, it's really, in essence, a trust arrangement. So it says the grantor deeds to the grantee, the public trustee, for the benefit of the lender. That's how, like a basic trust, like a living trust. And the instructions have in it what's called a power of sale for the trustee. And when the beneficiary, who's the lender, notifies the trustee that the borrower is in default, then the public trustee or the private trustee, whatever state you're in, follows a certain procedure to foreclose the property. And usually it's just giving a notice of default to the borrower and then publishing an ad in the newspaper for consecutive weeks, 4 to 6 consecutive weeks, and then there's a sale date. In a mortgage state, it's a little different. It's a lawsuit, a mortgage foreclosure lawsuit. So you start with a summons and a complaint, you file a lawsuit, you serve the borrower, you get the court to issue you a judgment or order granting sale, and then you go to sale. But in the end, it's all the same. There's always a sale at the end. There's always going to be a public auction at the end of the process. All right? So the only basic difference between a deed of trust and a mortgage is the process by which it is foreclosed. Don't confuse warranty deed, the ownership of the property, or a quitclaim deed, ownership of the property, with deed of trust. A deed of trust is a mortgage lien, or security instrument, or collateral instrument. Don't confuse the two. People often do that. Okay, everyone understand the difference between deed of trust and deed. Don't confuse the two. A deed is the title, ownership of the property. A deed of trust is the equivalent of a mortgage. All right, now, let's really get into liens, because this is very, very important to understanding the foreclosure process and what the opportunities are for you in the foreclosure process. So let's work on liens. There are basically 3 types of liens. There are statutory liens, voluntary liens, and involuntary liens. let's start with voluntary liens, because you're probably most familiar with those. And those are liens that are placed on the property voluntarily with the consent of the owner, such as a first mortgage, second mortgage, or if you want to use the vernacular, first deed of trust, second deed of trust. But I'll use mortgage, deed of trust throughout the weekend, sort of interchangeably, because they're essentially the same thing. The involuntary liens, such as judgments and IRS liens. Now, voluntary and involuntary liens are first in time, first in right. First in time, first in right. That means the order or priority of the lien is based upon the time it was recorded, unless the document has in it what's called a subordination. You should be on the lookout for that when you do your title searches for your foreclosure properties. It's possible for a second mortgage to be in first position. How? It's called a subordination. The first signs a subordination agreement, allowing itself to step back and allow another lien recorded after to jump into first position. So if you see that, and just look for a subordination agreement on file, that's what that means. That means this first mortgage has allowed another mortgage to step in first place, in front of it. Money. Sometimes it's the same lender, and they're allowing it for whatever reason. Sometimes there's just enough equity in the property, so that if it's a $200,000 property and the first mortgage is $30,000, and another mortgage of $50,000 wants to place the lien on there, no big deal, right? Because the second mortgage is still 80 cents to $200 on the mortgage. Sure, if there's an 80% loan and a 20% second on the property, and the first wants to refi, what happens when you pay off the loan? What happens to the loan? It moves away, and the second mortgage steps in front. So you need the second to sign a subordination to say, hey, stay in second position. Does that make sense? And it's sometimes you have to look for these things. Sometimes you have to deduce it by the amounts. You'll look at a title search that says first mortgage 80, second mortgage 20, and then you'll see another mortgage of 90. Well, does that mean there's 3 liens? No, it's possible that the 2 loans were refinanced into one, the 90, and someone forgot to record a release. So you have to do a little common sense on that. If the property's worth 100, chances are there's not 3 liens on the property. Chances, but don't automatically assume that. Don't automatically assume that. Do a little deductive reasoning there. So, voluntary and involuntary are first in time, first in right. Statutory liens go to the head of the line. So statutory liens are things that are a lien as a matter of statutory law. The law says in the statute, this is a lien whether or not it is recorded. Because typically to be a lien, what has to happen? It has to be recorded down at the clerk's office. First mortgage, second mortgage, judgment, IRS liens have to be recorded in the clerk and recorder's office of the real estate records in order to be a lien upon the property. A lot of people think that the IRS has some special priority in liens. They don't. They go to the back of the line just like every other lien. So if they're recorded fourth, they're in fourth position. As a practical matter, though, because the IRS has a long redemption right under federal law, you have to, as a practical matter, always negotiate off those liens. You call the district IRS office and you negotiate with them. And a lot of times, if there's no equity, they'll let it go. Now, they still want to reserve the right to go after the homeowner, the taxpayer. And that brings us to another point. There's a lien and then there's a debt. 2 different things. So, for example, when you sign a mortgage, what are you signing? A note and a deed of trust. So if the deed of trust falls off the property for whatever reason, what happens to the debt? The note, is that wiped out too? No. So the debt is a personal obligation of the borrower. Same thing with an IRS lien. You can get the IRS to take the lien off the property, but they'll say, no, but we want to go after the borrower. So these things start to become negotiable. We're going to work on that a lot this weekend. First mortgage, second mortgage, judgment, IRS lien. Depending on how much each of those are and how much equity is in the property will depend on whether or not we can get rid of those. There's two ways to get rid of a lien. One, you pay it off in full or at a discount negotiated, or you buy it. You buy the lien from the owner of the lien. So you go to the judgment holder, say, you've got a $3,000 judgment. I'd like to buy that judgment for $500. Why would they sell it for $500? They're in third position. What happens when a first mortgage forecloses? What happens to the liens behind it? They get wiped out. They get wiped out. Not does the debt get wiped out? No, just the lien. So what happens if the second mortgage forecloses, not the first? What happens to the first mortgage? Still there. Because it only wipes out, foreclosure only wipes out junior liens, the liens behind it. So if the second mortgage foreclosed, you have to pay off the first or keep it current, but it wipes out the judgment and IRS liens behind it. What if, for example, this property was worth $200,000 and you had a $120,000 first and we had a $30,000 second and we had a $50,000 third, which is a judgment. Could we make a profit here? Theoretically, we can buy that judgment, foreclose that judgment, and wipe out whatever's behind me. Let's say a $50,000 IRS lien. Wipe that out behind us. But what do we have to do? What do we have to pay off? First and second. So first and second is $150, and if I pay $500 for the third, is that pretty good? Yeah, I got the property for basically $150, $500 for a property worth $200, assuming it's in good shape and it's a good neighborhood. That's a pretty good deal. So we go to the judgment holder and say, I'd like the right, I'd like an option to purchase your lien. An option. To purchase that lien. When you close, you exercise the option. So you get in writing from the lien holder, I agree to take X dollars for my lien on or before such and such date. When you go to close, you pay off that lien based upon that written statement, and they can't change it. After once they put it in writing, they are, $50 legal word, stopped from denying that's the amount. Okay? So you could buy the second mortgage. Let's say we went to the second mortgage and said, we'd like to buy that. You're owed 30, I'll pay you 30, or I'll pay you 20. So we can buy that lien and then foreclose the second, and what happens to the judgment behind it? Falls off, gets wiped. So does the fourth, the IRS lien. Or we could just buy the property from the homeowner and then pay off the $30,000 at a discount. That's a short sale. Are we going to pay off the $120? Probably in full, because there's a lot of equity position for the first. Okay, so we're going to go back over and over and over again. I'm just throwing out a couple of flavors and ideas so you can get a feel for how this works. But really important that you understand lien priorities and how they work, how to release them. That's different. That's different. Now, there's a couple of little wrinkles in HOA dues. Let me talk about that. HOA dues are not only a lien if they're not paid, they are a personal obligation of the homeowner, which is why you never take a deed in your own personal name in an HOA association. How do you think that I know that? They will go after you personally. They could sue you in small claims court and forget about the property and just sue you individually and get a judgment against you personally and go after your personal assets. They can do that. So you always take title in a trust or a corporate entity that can take the hit for that. Some entity you don't care about walking away from. Okay? So now, those are first. So if the first mortgage forecloses, does that wipe out property taxes? No. Water and sewer? HOA dues. Well, here's the thing. Colorado's a little unique. And I believe it's the same way in most states, too. There's a certain cutoff period. In Colorado, there's 6 months. The first 6 months of dues and assessments owed are a primary lien, a super priority lien, goes to the front of the line. Anything more than 6 months goes to the back of the line according to when it accrued. So in Colorado, we have what's called bifurcated HOA liens. There you go. There's another $50 legal word. You're getting your money's worth. They're bifurcated. Means half of it, so let's say a year of dues is owed. Half would go to the front, half would go to the back. So when you're negotiating with the HOA, then are they going to negotiate the first 6 months? No, they're not going to negotiate the first 6 months. You've got to pay it because they're in front of the line. What about anything after that? That is negotiable. And typically when you go to a bank and a bank REO, when they sell you the property, the bank has to pay that. The bank will take care of that because they're liable for it. Typically they've owned the property for about 6 months, so they're liable for those dues. Okay? And there's no distinction between junior and senior there, the bifurcated lien, because the bank owns it. They own it free and clear. So if there's 6 months of dues or 12 months of dues, the bank's going to have to pay it all as a practical matter.
So you might have a $100 HOA and then a mechanical and then another $100 HOA because the mechanical came in.
You say mechanics lien? Yeah. Let's talk about mechanics lien because that's nowhere in here.
But if the HOA was in July, you owed this in July and then there was a mechanics lien or whatever and then another $100.
And then another $100 in HOA would step behind according to when it accrued. But a bank owns it free and clear. It's all one lien. It's all going to be owed because there's no other liens on the property. Now, we haven't talked about mechanics liens. Mechanics liens are odd because they are statutory, but they don't go to the front of the line. They're sort of a cross between statutory and involuntary. They're a claim for unpaid work or materials. So it's not really like a regular debt. It's a claim not against a person. See, all of these are a claim against a person. First mortgage note, second mortgage note, judgment against the person, IRS lien against the person. These are claims against the property, except for the HOA, which is also an obligation against the person. And a mechanics lien is a claim against a property, not a person. So they can't sue you personally, unless, of course, you're the one that hired them. What they do is they file a mechanics lien, and it goes in order or priority of when the debt, or not the debt, but the obligation underlying the mechanics lien accrued. When the underlying services were provided, which is usually going to be back of the line. Usually. Make sense? Now, as we'll talk in a minute, that lien has a valid redemption right. The simplest and most practical way to deal with a mechanics lien because it has a life. Mechanics liens are not good forever. In Colorado, they're good for about 11 months. California, I think it's 12 months. I don't know what it is in Texas. Probably about the same. Usually they're about a year. And then after that, they just fall off. They're not effective anymore unless the person files a lawsuit to back up the claim that they're owed money. So if you see a mechanics lien that's old, you ignore it. If it's a month ago, you're going to have to deal with it by going to the contractor and getting him to release that mechanics lien. What does he sign? Release of lien. Release of lien, okay? Any questions so far about liens? We'll make sure you're all experts on liens. Yeah?
HOA dues.
Mm-hmm.
What if the HOA has assessed interest on late dues? Is there an obligation to pay that as well? I mean, I guess it would fall to the homeowner, but it would,
you're going to have to, as a practical matter, you're going to have to deal with it. It's a practical matter, you got to deal with it.
would that normally be negotiable off because it's not part of?
If they're in first position, if it's in first position, you're going to have to pay it.
Okay, even interest aside.
Yes. Yes, Damien.
Why do the HOAs have so much power? I mean,
That's the state legislature just did it that way. They decided to make sure that the HOAs have the right to get paid back. Because otherwise they'd always be broke and they wouldn't have money, so they did it that way on purpose. Yeah.
HOA, supposing it's a special assessment on new roof.
Good one. Special assessment. As long as the special assessment does not exceed the equivalent of 6 months of dues. If it is more, then it goes behind. To the amount that it exceeds 6 months worth of dues, it jumps to the back of the line. Okay? Any other questions on liens before we go on? Okay, let's move on to the stages of foreclosure. I'm going to go through the general. This is how it's done in just about all 50 states. So basically we start with a default. And what does default mean? Non-payment. 1 month non-payment is a default. But the bank can choose when to accelerate the note. So they can always say, hey, you're late. Here's your monthly payment plus the late fee and the last month's payment. And they can keep doing that for month after month after month until they decide to accelerate the loan. Now, FHA usually waits 3 months and then they accelerate. But other banks, other lenders, there's no rule that says one way or the other. They just do it when they want to do it. And it depends on the property. So, for example, if the property is worth $500,000 and it's an $800,000 mortgage on it, are they going to be in a rush to call that in? No, they're not going to be in a rush. And if the homeowners had any contact with the lender in the meantime, made partial payments, said, hey, I'm working on this, I'll have you payments in a week. If there's any contact between the homeowner and the lender, chances are it's going to be even longer. Okay? So if you are, let's say, working with a homeowner in pre-foreclosure before the, not pre-foreclosure, but pre-filing of the foreclosure action, and you want to buy more time, what do? Tell the homeowner, call the lender, and start having a conversation. Start making empty promises about, when they're going to pay their mortgage, or partial payment, or something like that. Yeah?
Can the bank come back and say, okay, I changed my mind, I'm going to foreclose?
So if they're working with a loan mod with a homeowner, in the middle of that, they can be foreclosing the property? Absolutely. They don't have to do anything they don't want to do. Typically, they'll put that on hold. Typically. But I've seen banks right in the middle of it, of the process, the homeowner says, yeah, I'm working on a loan mod, and all of a sudden they get a sale date next week. It happens. So a lot of times it's because the bank, one hand doesn't know what the other one's doing. That's usually the cause. So if you're working on something with the bank, you want to always be calling and calling and calling to make sure that the property doesn't go to sale. Because we learned that the hard way, right? So we start with the default. Anywhere from 3 to 6, 9 months goes by. They accelerate the loan, and then they file the foreclosure action. Okay? That's the notice of default. If for a trustee, for a trust deed, for a mortgage, it'd be a summons and complaint, or a filing of in mortgage states, they file a lis pendens first. That's a notice of a lawsuit, and then they file the lawsuit. So that's your first public notice of it. In Colorado, we call a notice of default a NED. NED. Slightly different. It's called Notice of Election and Demand. Basically, think of it the same thing as a notice of default. That's NED, NOD, whatever you want to call it. Now, then an auction date is set. Now, in between the foreclosure starting and the auction, which is depending on your state, Colorado's about 3.5 months. Most states are about that, about 3 months, except in Texas. 21 days, hang 'em high. But most states are about 3 months. Nevada, what is Nevada, Frank, about 3 months? Most states are about 3 months. From the beginning of the foreclosure, the notice of default, and the auction date. 3-4 months. So that's the process is in foreclosure. Now, anytime up to the auction, we can cure. That means pay up the back amount. You can always pay up the whole amount. But anytime up to the auction, we can make up just the back payments and cure the loan. Fix it. Put it back where it was before it went into default. And then we have the auction itself. And then after auction, in some states, we have a redemption period. Colorado used to have a long redemption period. They knocked it out. Now there's what's only called a leaner redemption, which means the junior liens behind the one being foreclosed have one more crack at it. I'll explain that in just a bit. So let's go through the different stages there. The auction, number one. The lender starts by bidding the amount that they're owed. So the bank comes up with their bid. The high bidder wins. Now in Colorado, since there is a leaner redemption, the high bidder gets what's called a COP, Certificate of Purchase. They don't get the deed right away. They get a certificate. I think it's the same way in Nevada, isn't it? They don't get a deed, actually. They get a certificate of high bid, and then they turn that in a couple weeks later for a deed, right? I think that's most states is that way, too. So the high bidder gets a certificate. It says, you're the high bidder. Now, the trustee issues the deed after the end of redemption. So if there's no redemption, like in California, you just turn in that certificate for a deed. In Colorado, we've got a short redemption period for the lieners, and if no one else redeems, you get the deed issued from the trustee.
So can the property owner redeem it?
No. Once the sale date goes, no rights in the homeowner. Now, like in Michigan, Michigan has owner redemption, then there is another crack at it. Colorado used to have the 75-day owner redemption, if you remember. They had 75 days after the sale to pay up, basically pay off the high bid amount plus interest. That was their last crack at it. The auction wipes out junior liens. So when you have an auction and a lien is foreclosing, it wipes out all liens behind them, not liens that are superior or senior in front of them. That's if the bank isn't the high bidder. The bank could be the high bidder. So let's say, going back to our example here, we had a $200,000 property, a 121st, a 32nd, and a 53rd, which was a judgment. Now, the second's in pretty good position, right? Because they've got basically $80,000 of position there. That's the difference between the first and the value. So they've got an $80,000 position. The third doesn't have much. They've got a $50,000 position because eventually they have to pay off the first and the second one, 20 and 30. Make sense? If the first forecloses and the high bid is 120, and let's say you bought the second, is that good? No. 120, no. If the high bid was 120, there is a lien of redemption in Colorado. You can come back and jump in and redeem it at 30. Does that work?
Yeah.
Yes. But what if the 120 was bid up to 160? Could that happen? Yes, absolutely. Usually the lender bids the amount owed. And if there's equity, doesn't matter if there's, when I say equity, that means the difference between the lien foreclosing and the value. Doesn't matter if there's 6 liens in between, because those all get wiped out. The bidding will start going up and up and up and up to the point where someone will bid it up to the point where there's little or no equity left in the property. If that happens, then the junior liens are in jeopardy, because when they go to pay it off, to redeem, which we'll explain in a minute, what do they have to pay? Not the original amount. Right, the bid price plus interest. Question?
The first lien, they're actually going to probably bid the total. Are they Are they only allowed to bid the known value, or will they actually? Because it'll probably
No, they can bid.
36.
They could bid less. They can do what's called the deficiency bid. So they bid less because in their mind the property's worth less. So the property's going down in value. They'll underbid, and then when they do that, they're reserving the right to go after the homeowner for the deficiency, for the difference between what was owed and what was finally bid. So let's say it's worth $200, and the first was $220. Okay? They could go in and bid $200, and if no one else bids, they could sue the homeowner for $20 for a deficiency bid. Now the homeowner can come back and challenge it and say that wasn't fair, that you shouldn't have underbid, it wasn't right, you know, the value was there, and yada yada, you sold it too low. They can do that. But that's why a lender will underbid. Has anyone ever seen that? A lender underbid.
Yeah, but if the homeowner's already filed for bankruptcy.
Well, yeah, if bankruptcy is going to wipe out the deficiency, sure.
So in that case, if the lender comes to the auction with a lower amount, it's because they think the property's worth higher.
Well, in that case, let's say they bid $200 and the homeowner owed $220. They're saying it's only worth $200. So they sell it for $260. What's the homeowner going to cry? Unfair. That property wasn't worth $200, and how did you sell it for $260 a week later? So they're gonna argue that that was unfair, and basically the underbid was not equitable. Okay. All right. So now cure versus redeem. Cure fixes the loan. Cure fixes the loan. Meaning, when you cure a loan, you make up the back payments, plus interest and such, and you put the loan back in place. So it's current, the foreclosure goes away, and we're back to our original position. Okay? Let me just back up for a second and let's get something out of the way. This is the cure period before the auction. After the auction is the redemption period, if there is one. What does pre-foreclosure mean? Before the auction, or is it before the foreclosure was filed? Well, it depends. I mean, there's no... We have to agree, right? We have to agree on something. So, most of you seem to agree that any time up to the auction is pre-foreclosure. Up to the foreclosure proceeding, before that is called pre-action. We'll call it pre-action, pre-filing, or pre-action. So before the foreclosure is filed, it's pre-action. Anytime up until the auction, pre-foreclosure. Okay? At least we agree on that. All right. So, we covered the auction. Cure fixes the loan. Redemption pays it off. So you could redeem theoretically any time. Up until the sale. That means pay the whole thing off. And if you have an owner redemption in your state, which I don't think anyone here does, an owner redemption would pay it off after. Now, how much is the redemption amount? If it's before the sale, it's what's owed. If it's after the sale, it's the bid amount plus recurring interest. At what rate? That's correct. It's the default rate on the note. A lot of you don't know this. If you've ever read a promissory note, like a bank has, it'll say the interest rate's 6%. But if you go into default, it steps up to 18%. They're trying to, a lot of legislators are trying to knock that out, so you can't do more than 11 or 12 or something like that. They're trying to knock that out, so making that lenders unable to do that. So that's why you wonder, gee, how did this thing get so big so quick? Because when they went into default, they stepped up the interest rate at 18%. What some people used to do when we had owner redemption 75 days is they would bid at the sale knowing full well that the owner would redeem just so they can get 18% on their money for 2-3 months. Right? Yeah. 3 months at 18%. That's a pretty good rate. Yeah. All right. There's two types of redemption. Owner redemption, lien redemption. I said most states do not have redemption rights. There's a handful that do have owner redemption. And in owner redemption, what do? You pay off the bid amount plus recurring interest. Liener redemption is and these are statutory rights, by the way. This is the legislature said, this is what your rights are. The lieners, that means the liens that are behind the one that's being foreclosed. So if a first is being foreclosed, the second and the third and so forth, have another crack at it and to redeem. And by redeeming, they pay up how much? The full amount of the bid, not of the amount of the loan, the amount of the bid, plus interest.